In this video, we'll be discussing about the changes made in the earlier criminal procedure code by introducing new Bhartiya Suraksha Sanhita, the new CRPC, and we'll be discussing only the changes done in the earlier procedure. Whatever are the new provisions, we'll be discussing only those portion of the new Bhartiya Suraksha Sanhita, which is known as Bnss. According to the new act, the metropolitan areas and the magistrate and the metropolitan chief magistrate, these provisions are now abolished. Also, the assistant sessions judge post, the designation is also abolished from the provision of CRPC. Now, BNSS does not provide for those jurisdictions. So, this is the change made in the jurisdiction of the court. Only metropolitan area, metropolitan magistrate and CMM, and also the post of assistant sessions judge. So, both of these jurisdictions are now abolished from the earlier criminal procedure. Now BNSS does not provide for those jurisdictions. Now judicial magistrate first class can award fine of 50,000 up to 50,000. The sentence, the imprisonment is same as earlier, even in case of JMSC and JMFC both. 1 year for second class magistrate and 3 years for first class magistrate. The power to sentence the imprisonment. And about fine, now it is increased to 50,000 from 10,000. It was 10K for JMFC and 5K for JMSC. Second class 5,000 तक का fine impose कर सकता था, but now it is 10,000. There is new introduction of the new kind of punishment which can be given by JMFC and JMSC both, and that is community service. So what is community service? Community service is given under section 23, explanation of section 23, and it according to the same, that work which court may order a convict to perform as punishment and benefit society, for which he shall not be entitled to any remuneration. So without any remuneration, anything ordered to be done by a convict for the benefit of society, and that is community service. So there are some objects why this has been introduced, and it is for reducing the prison population first and reducing the state expense, as these convicts are always kept in a system there behind bars, where there are certain expenses which are basics for people for their living, for their food, for their clothes, and every management possible for living. So it will reduce down those expenses of the state. And third is to focus on rehabilitation and reformative form of punishment. By community service, there obviously the courts are not punitive. They're not inclined to award punitive form of punishment, but by ordering them community service, that will definitely be a reformative step for their rehabilitation. So that's the purpose, the object of community service, the introduction of new kind of punishment there in the BNSS. Now there are some reforms made in the jurisdiction as well of the certain authorities. So now, as per section 14(6), state government is now authorized to confer all or any powers of executive magistrate to a commissioner of police. Whenever this is necessary, the state government can authorize an executive magistrate, the power of executive magistrate on commissioner of police. That is something which was not there in the earlier act. Also, state government is authorized to appoint special executive magistrate, whom any police officer not below the rank of SP or equivalent to, in addition to an executive magistrate. So now state government can appoint any a police officer not below the rank of SP and a special executive magistrate. So that is under section 15 of the new BNSS. Now there is another change made by the Parliament under this act, a slight change, but not something which was not clear in the earlier act, but now it has been stated clearly, directly, that when in cases involving several offences, the court considering the gravity of the offence shall order punishments to run concurrently or consecutively. In the earlier act, it was like that if the court does not write it down like that, punishment, the sentence shall run concurrently or consecutively. It was the understanding, it was the provision that if it is not expressly written, they shall run consecutively. So now it is to be expressly written in the judgment by the presiding officer that either you have to write it that the punishment shall run concurrently or consecutively. So this is to be done expressly now, and this is provided under section 25 of the act. Further, district directorate of prosecution has been introduced in every district, and also deputy and assistant directors of prosecution. Director of prosecution will be giving opinions on monitoring cases punishable with 10 years or more, or LI or death, and also on filing their appeals. So this is the responsibility of director of prosecution to give opinion and monitor these cases where the punishment is up to death, LI or death sentence, and also whether appeals should be filed or not. This is the responsibility of director of prosecution. Deputy director of prosecution is duty bound to examine police reports and to monitor the cases punishable for 7 years or more but less than 10 years. So for ensuring their expeditious disposal. Now, according to section 40 of the Bnss, whenever anybody is arrested by a private person, his protection shall be made before the police officer or nearest police station within 6 hours. So whenever a private person is arresting any person, he must produce the person within 6 hours of his arrest before police officer or nearest police station. Any offensive weapon found on the person of arrested person have to be seized immediately and to be taken before the court or officer before whom the arrested person is to be brought. So whatever offensive weapons are found to be, they should be immediately be seized and to be taken before either before the person before whom the arrested person is to be produced, and that may be police, and also either before the court, which is section 50 of the act. Now there has been an introduction of time limit for medical examination reports. So now the medical examination report of victim of rape, specifically victim of the rape, to be forwarded by the registered medical practitioner within 7 days to the investigating officer, and also to the who shall forward to the magistrate, which is section 66. Earlier there was no such limit, but now within 7 days the medical report must be given. Now there is the summons can be electronically be sent, and service on any adult member has been the provision now, because earlier it was only to male member it could have been made. Now it can be made to any adult member of the family. So now the service of summons is gender neutral, and electronic communication is also now introduced, that summons can be sent electronically as well. Earlier in FIR there was no direct provision of 0 FIR or EFIR, but now 0 FIR and EFIR introduced, expressly written in the new act. So the provision about the same is that upon EFIR, OIC to record the information on being signed within 3 days of the person by the person giving the information. So whenever the EFIR is received by the officer in charge, he must get the sign of the informant within 3 days on the copy of FIR. So this is section 173. Now preliminary inquiry of cases punishable with 3 years or more but less than 7 years is mandatory before registering an FIR on the matter. Earlier it was not the express provision, but the judgment of Honorable Apex Court, and that in such some matters there must be a preliminary inquiry which can be conducted by the police. Now it is the express provision. Also, preliminary inquiry shall be completed within 14 days. So this is also a timeline for the preliminary inquiry. Now this is the responsibility of police officer to inform the progress of investigation to informant or victim within a period of 90 days through any means, including electronic communication. So earlier there was no such provision. Now the police officer is to inform the victim or informant about the progress in the case. So this is section 193 subsection 3. There is also another new provision introduced under section 196 subsection 6, that judicial magistrate, executive magistrate or police officer conducting inquiry or investigation into custodial death, they must forward the body for post-mortem within 24 hours. So this is an express provision about the custodian death, where 24 hours is the time limit to forward the body for post-mortem. There is another time limit introduced in cases of government sanction. So whenever government sanction is required in cases where the public servant is being prosecuted, so time limit is set up to 120 days from the date of receipt of request of sanction. So sanction either being given or not given, that must be expressly informed within 120 days. And if it is not being decided in that time limit, it will be deemed to have been accorded, which means sanction will deemed to have been given that that person can be prosecuted. Now magistrates are empowered to take cognizance upon receiving police report electronically, and also service or process or summon can be done electronically as well. So now even if an electronic mode, say police report is sent, then there are also the cognizance can be taken by the magistrate, and also the accused must be supplied with police report or other documents within 14 days from the date of production or appearance. So there was no time limit earlier with that regard as well, but now 15 days, within 15 days the police report and the documents must be served to the accused by the police. The documents can be supplied electronically as well. So now if you can see that everything is now allowed electronically, even the service, even the sending documents of the case. So this act is also recognizing the technology, necessity of technology, and as we are moving more towards paperless system now, whenever committal is to be made, it must be done within 90 days from the date of taking cognizance. As committal is to be done in cases where the case is triable by any superior court, especially when it is the matter trial by court of session, there committal is to be made by the magistrate, and the time limit is now set up to 90 days or further 180 days with reasons recorded in writing. So this is section 232 of the Bnss. Now there is a provision of application for discharge, and that must be made within 60 days from the date of commitment of the case to the court of session. So this is with regard to matters which are triable by court of session, that whenever the application for discharge is to be made before the court of session, that must be made within 60 days from the date of the case is committed to the court. Charge is to be framed against the accused within 60 days from the date of first hearing, which is section 251. Earlier there was no such provision which was setting this time limit. There was no time limit for the same, but now from the date of first hearing, within 60 days, it is the time period within which the charge against the accused should be framed. Audio video mode for deposition of evidence, statements of witnesses, police, public servant, etc. Now it is directly primarily can be chosen, and it is the one of the alternative now provided under the act for recording the depositions. So audio video mode can be opted for deposition of the evidence or statement of the witnesses. So this is section 265. Now discretion is conferred on CJM and JMFC to decide whether summary trial should be conducted or not in cases where the punishment is not exceeding 3 years, right? So in those cases, after giving opportunity to the accused, the court can decide to try the accused summarily, and also where the value of property in cases of theft was 2,000 earlier, now it has been turned to 20,000, and also where the value of property is also 20,000 in cases the offence of receiving or retaining stolen property or assisting in that commission. The screen is not showing the whole provision here, but it is also 20,000 in this clause as well. Here the amount of fine has been increased in certain summary trials. So in summary trials for giving false evidence, earlier the fine amount was 500, now 1,000 is the fine amount. For contempt it was 200, now it is 1,000. In cases where the non-appearance by the witness and disobedience to the summons, it was 100 earlier, but now it is 500. So these are the fine amounts now increased to some limit. Some changes are made in the timelines for delivering judgments by the courts. So for a judgment by any criminal court, it must be the judgment must be pronounced within 45 days from the date of termination of the trial. So when the trial is terminated, the judgment must be passed within 45 days from that time. And in cases of sessions court, it must be delivered within 30 days, but further days can be by writing reasons up to 45 days. So with 30 to 45 days is the time period for sessions court, and it is from the date of conclusion of the arguments. And the copy of the judgment must be uploaded on the server as per section 392 within 7 days of the passing of the judgment. So this is the time limit for certain time limits for delivering judgments. So this is part 1 of the video. I'll bring another part, what provisions are now, the changes now remained. I'll talk about those changes. Thank you so much for watching.